Welcome to another episode of Tax Break. I'm Steve Dixon, a tax litigator at Miller and Chevalier, and I'm joined, as always, by my colleague Loren Pons, who works in international tax and tax policy at Miller and Chevalier. As we've said before, Tax Break is a podcast that's meant to bring you topics that, some insight into topics that we think are interesting in the tax field. We're going to talk about a topic today that I find particularly interesting and I've spent probably too much time on given the outcome of the case. As always, a disclaimer, a tax break is not meant to be legal advice and you cannot rely on it as legal advice. It reflects only the opinions and insights of its hosts and or guests. In this case, it'll just be the two of us hosts. So what we're going to discuss today is the Altera case. And this is a little bit after the fact because, as many of you probably know, the Supreme Court denied Altera's petition for certiorari last week. So this brings an end to a very long saga for these cost-sharing regulations. And we wanted to talk about a couple of things today. One is the Administrative Procedures Act, or the APA, as it's known. That's something that tax lawyers now need to actually become fluent in. That wasn't always the case. So we're going to talk a little bit about the mechanics of the APA. We're going to talk about the issues that were framed in the Altera case, not with probably the depth they deserve, but enough to give you a sense of what was going on in that case. And I want to sort of close out by talking about the denial of petition for cert, because we're going to talk a little bit about DACA today and Dreamers. The Supreme Court, just before it denied Altera cert, actually decided a case on DACA. As you probably all know, it's a landmark decision that relied on some APA principles. And those APA principles ought to have been relevant to what happened in Altera, although ultimately now we're not going to find out how those principles would apply.
We'll never find out, but they have relevance for the future, right? We have more new tax regulations that have been promulgated since the 2003 cost sharing regulations. Thank goodness. So this is still relevant, and
yeah, that's right. Highly relevant, and especially in the wake of all of the regulations that Treasury's had to enact in order to interpret the TCJA, which is
right.
a sort of seismic shift in the law, and heavily reliant on Treasury interpreting the statute through regulations.
Absolutely. There are many grants of regulatory authority sprinkled throughout TCJA. So we have plenty of opportunity. I thought you were going to start with our hook, which is, what does immigration have to do with tax? But
you can spin that.
No, it's too late. I mean, we already have our reader. We didn't have to do the bait and switch for our listener.
Well, we will talk a little bit about what immigration has to do with tax in a very narrow context.
In a very esoteric way, as we are known to do.
That's right. That's right. So to kick it off, I think it'd be helpful to give our listeners just a little thumbnail sketch of what the APA is about, because usually we start out and we're talking about something in Title 26 of the United States Code, and we're not in the code with the APA. We're in a different area of the law. And so just a sort of quick sketch of what the APA is and what it's meant to do. So going way back to early 20th century history, obviously in the wake of FDR's New Deal, there was a glut, if you will, of administrative agencies that cropped up in the executive branch of government. Many of these agencies were given, as they should have been in order to function, rulemaking power. Part of this is just sort of the advancement of the technocratic state, right? We need the economy and businesses are complex and need lots of regulation. And in order to administer and create those regulations, we have to have executive agencies doing it. There was a concern, rightly so, that administrative agency rulemaking could become too powerful. And the APA is meant to essentially put that into check. So it was enacted in 1946. And the idea is that we can rein in the rulemaking power of administrative agencies by forcing them to follow particular procedures, administrative procedures, if you will, that ensure that the agency rulemaking process is more like legislation. Now, it obviously isn't not going to be legislation. It can't be, that's impractical. But there are several elements of the APA that are meant to address this. And I want to just talk about a couple in particular. The first is notice and comment. So if your agency is going to enact regulations that will have the force of law, which regulations do, then it has to provide notice, public notice of the rules, and accept comments. Now, Loren, this is a process that obviously I think you're very familiar with in
I
terms
am
of
very familiar.
making comments on regulations. I know that's something that
That I do.
that you do.
That we do.
Yes,
We do.
yes, it factors into your practice. So certainly more than the practice of someone like me who does litigation. And that's sort of part of the services that lawyers can provide, right, is to sort of help you navigate this process of making comments. But the idea is a simple one, right? These agencies are not going behind closed doors and making rules.
Right. So they want it to be a more deliberative process akin to legislating, right? So you have some time. You have time to review. In the legislative context, this would be what's known as lobbying. You have an idea about what you want the bill to look like. You spend your time talking to legislators, and hopefully the bill, if you are effective, is modified to reflect your concerns. And so the comment period is kind of a similar process whereby concerned, in our case, taxpayers or any other affected individual or group of individuals by the proposed regulation would take the time to review the proposed language and write in a comment letter about why they think a certain provision doesn't work appropriately, ideas for making it better, more tailored to the intent of the statute, which the regulation seeks to amplify. So that's the purpose.
Yeah, and it serves, as we'll see in discussing the Altera case, it also serves another purpose, which is to record effectively, to create a record of concerns that folks have raised about the rulemaking and what the effect of the rules. Because it's not, if the agency decides to not act on comments or ignore comments, that's something that becomes reviewable by a court. And that's the second aspect of the APA that I wanted to mention, is that essentially it provides for judicial review of agency rulemaking, so that the judicial branch acts as a check on the power of the executive, just as it acts as a check on the power of the legislative branch vis-a-vis the Constitution and other elements of the law. So I want to sort of talk for a second, and I don't want to be too critical because I worry that sometimes on these I get a little critical, but there is, there is a history of there's a sordid history between the Treasury Department, and in this case the executive agency that makes regulations for in tax, and the APA. And for many years, Treasury acted as if many elements of the APA did not apply to tax regulations.
It was an example of what we call tax exceptionalism.
Tax exceptionalism, that's right, and that's what it's sort of became known as. Although I wonder whether the tax exceptionalism term is something that is more has entered the parlance more now that it is dead than it did.
Before it was never spoken of; it was just
That's
understood, and now that it's gone, everybody's talking about it.
Yeah, and right. I mean, there really was an element, at least for those of us who practiced before Mayo and the end of tax exceptionalism, there was an element of a kind of agreed truce between taxpayers and Treasury that the APA was not necessarily beside the point, but not at the front and center of the tax rulemaking process. And this in part had to do with, so I think probably folks have heard of Chevron and Chevron deference. That case for many years was, I think, largely ignored in the tax bar, and in favor of another case that addressed a similar set of issues about agency rulemaking in the tax context specifically, which was national muffler.
Yep.
And I think folks thought of it as sort of an alternative or parallel universe of Administrative Procedures Act and deference issues. But of course, this all ended when the Supreme Court decided the Mayo case and effectively said that Treasury regulations are just like any other regulations, and they are subject to the same kinds of judicial review that any other agency rulemaking is.
Right.
So Treasury, I mean, in saying that Treasury's compliance with the APA has been spotty over the years, is in part due to this effectively a sort of agreed truce about tax exceptionalism. But Treasury also had a spotty history when it came to complying with the notice and comment procedures under the APA. So in order to make the rulemaking transparent, notice and comment has to be sort of a public process that gives the public a chance to comment on the regulations. And Treasury has, Professor Kristen Hickman at the University of Minnesota Law School has published a lot on this. There's some really good pieces. They're actually pretty readable, so I'd recommend them. But she did a study on how often Treasury actually went through notice and comment with its regulations, and over a very small period found that Treasury almost never offered its regulations up for notice and comment. It often claimed an exemption from notice and comment with little more than a perfunctory explanation as to why it was exempt from notice and comment. Again, it had reasons. I mean, these were rooted in some of the standards and the old distinction between legislative and interpretive regulations. There are reasons why Treasury did that, but in any event, we are entering a new phase for tax rules.
Right.
And in terms of judicial review, I mean, there are a couple of standards that are out there. I mentioned Chevron, which is the famous two-part test that essentially asks the Chevron two-step, as it's widely known, that essentially asks whether or not the statute is ambiguous, and if it is ambiguous and the regulation does not agree with the statute, it can be stricken. If the regulation is ambiguous, then Chevron asks the court to look at whether the agency has reasonably interpreted the statute. Then the other standard is under this a famous case, State Farm, which essentially requires agencies to go through what's known as a reasonable decision-making process. So essentially, this is a way of looking at how did the agency come about just choosing its rules. And look, you can imagine all kinds of examples as to why we should have a principle like that. If you were to have an agency that has a lobbyist appointed by an administration whose goal is to essentially tear down the functioning of that agency, then courts ought to be able to look carefully at whether that agency's rulemaking process follows some basic principles of reason and considers the evidence before it.
Right. So despite the APA, its stated purpose of acting as a check against unfettered regulatory action, it obviously has some shortfalls if the courts have to step in and interpret compliance with the APA to begin with, right? So we have a line of cases, as you mentioned, national muffler used to be the standard for tax cases with regard to APA compliance, no longer. And so now we have the Chevron State Farm set of cases which kind of govern. And we'll get into Altera a little bit later, but that case calls State Farm into review.
Right, and brings it to bear in a way that is not novel, but important in this context. Yeah, that's
yes.
right. So so let's turn and talk about the regulation that's at issue in Altera. So it's a regulation under Section 482, which is your bailiwick, one of your many areas of specialty.
Yes.
Yeah. So tell us about how this regulation emerged and a little bit of the history of the cost sharing regulation that was in dispute in Altera.
I will, and to do that, I have to go back a little bit further to a case called Xilinx. But first, 482 is implicated. The regulation is 1.482-7, so the cost sharing regulations. And really, cost sharing is just a way for related parties to develop intangible property, share the cost, and then split the anticipated benefits of exploiting that IP in proportion to the amount of cost that each party has contributed. So that is cost sharing in a nutshell. And there are two sets of regs that are relevant for this discussion. The first governs qualified cost sharing arrangements, which is a set of regulations promulgated in 1995. And that's where Xilinx comes in. So in that case, it's the same question essentially as what's presented in Altera, which is whether stock-based compensation costs, the costs associated with giving employees stock-based compensation, are costs that should be included in the pool of costs to be shared in a cost-sharing arrangement. Now in Xilinx, those regulations were the old set. So you had a qualified cost-sharing arrangement, which is not what you would have today under the current regs. But largely, for our purposes here in the stock-based compensation discussion, the same. And in Xilinx, the regulations at issue had a phrase, this all costs language. And the issue turned on whether or not stock-based compensation costs were includable in that all costs definition. And so the tax court said, no, absolutely not. We're going to look at this through the lens of the arm's length standard. In this case, if you're going to comply with the arm's length standard, you have to look to what unrelated parties would do. And, the court said, no, we don't, third parties would not share these costs because we haven't seen any evidence that they do. So this all cost language cannot be encompassing stock-based compensation.
Which has the effect then, if you're a large domestic technology company that wants to develop some technology with its foreign subsidiaries, and you had to share the costs of your highly paid technical employees here in the U.S. in the pool of cost sharing, it would essentially drive your tax up.
Right.
Effectively.
Effectively. So there are many companies that have a vested interest in not including these costs in the cost pool for that very reason. So they appealed also to the Ninth Circuit. The Ninth Circuit first reversed the tax court and said, actually, you do have to include these costs in the pool. And then the Ninth Circuit reversed itself and came back and said, actually, no, you don't. You don't have to include these costs. This is not consistent with the arm's length standard. So don't worry about it. Xilinx, you're good to go. You can exclude the stock-based compensation costs. In response to that, the service promulgated proposed regs in 2002. And these regulations were directly addressing the stock-based compensation issue. And so the regs explicitly said, you have to include, there's a parenthetical, including stock-based compensation after this mention of all costs. And then there's a further provision in the regs that goes into what exactly stock-based compensation costs might be. So that was in the proposed regs. 2002, there was a bevy of comments from taxpayers saying, wait a minute, this is not what unrelated parties do. They proffered evidence. Everyone was very clear that this was not something that was consistent with arm's length because unrelated parties don't share these costs.
Well, and I mean, they're proffering the evidence that Xilinx used to win in the first instance.
Right. So one would think that Treasury would either find some evidence to the contrary, i.e. that parties do share these costs, or give some reasons why the proffered evidence was not credible. So why the evidence that taxpayers submitted in their comments just was able to be rejected for valid reasons, namely that it wasn't credible. So Treasury
and you can see here, if I just want to interject, you can see that we're on the path to an APA fight, because we have an instance where the Treasury interpreted the statute and its own regulation in a particular way, lost in Xilinx, and then tried to fix it by fiat, right? By agency rulemaking, which is within their power, but the conditions are ripe for because we have the agency enacting a rule, and a rule that is sort of now contrary to a decision that's on the books in the Ninth Circuit.
Right, a decision that's contrary to the books, and it's also a decision that they put forth, and no other circumstances have changed, other than they got an unfavorable ruling from the Ninth Circuit.
Right.
So, okay.
Other than the L, yes.
Right. Other than the L, nothing has changed. But here we go. We're going to do a complete and total flip-flop from what the reg said. We're going to clarify what the reg said.
That's right.
In contravention of a Ninth Circuit case on the same issue. So fine. The Treasury comes along and issues the final regs in 2003 and really doesn't, it just says, no, we're not going to accept what taxpayers have included in their comments. We're moving forward. No change to the stock-based compensation reference in the all costs subparagraph, and no change to the stock-based compensation definition. So we are now in final reg territory.
Right. And I mean, what's really important, right, especially for the sake of Altera's case, is what did Treasury say when it finally decided that we're going to enact these are the final rules, and we're rejecting this evidence of taxpayer behavior in the arm's length context. And what it said was quite little, actually. It didn't provide much in the way of why it is that this arm's length evidence is not relevant.
Right.
And moreover, Treasury claimed that in fact its regulation is consistent with the arm's length standard.
It did, but without, as I mentioned, either refuting the credibility of the evidence to the contrary or offering some new evidence.
Right.
So that's where we ended up with the 2003 regs. We have a new rule, not much in the way of support for the new rule, and we're going forward. So this brings in Altera, which was in a cost sharing arrangement from 1997 to 2007, but 2004 to 7 were under audit, and they did not share costs consistent with Xilinx, inconsistent with the 2003 final regs, and thus gave birth to the dispute.
Right. And so just to pick up the story there, the case went to tax court, and they were challenging effectively what was at stake was a challenge to the regulations, the now final regulations that required them to include employee stock option costs in their cost sharing pool. And they lost, or they won. The Treasury lost at the tax court in a kind of a not entirely rare, but a fairly substantial loss. It was reviewed. The decision was reviewed by the entire tax court, and it was a 14-0 decision. There were some judges that recused themselves, but yeah, they lost badly.
Someone called that a landslide.
Yeah, that's one way. That's one way to think of it. And so we have a 14-0 decision by the tax court saying these regulations are not valid, and the rationale was of a piece with the same reason that Xilinx was decided the way it was, however many years before, which was that there is arm's length there's evidence of arm's length behavior, that parties do not share these costs at arm's length, and the arm's length standard is the pillar, is the is the big note of 482, and if you don't comply with the arm's length standard, you lose, and that's so the tax court held for the taxpayer.
But I'm sorry, go ahead.
Yeah, but what's interesting, and the important thing, is that what the IRS argued in front of the tax court was that this regulation was consistent with the arm's length standard. They stuck to their guns and stuck to what Treasury said in its explanation, in its preamble for the final regulations, that this is what the arm's length standard means.
So were they stuck with that? I have two observations. Well, the first is a question, the second is an observation. So were they stuck with the arm's length argument because they were in the position of defending the regulation under State Farm, which calls into question empirical evidence, which calls into question what do unrelated parties do, which implies that arm's length is the controlling standard, because you have to look at what unrelated parties do to determine whether or not you're compliant with arm's length.
So I want to break your one question into two questions.
And I still have my observation.
Yeah. Well, I mean, the question, right, is were they stuck? Well, the answer is, does the law provide that they were stuck? I think there's a pretty good argument that it does, and that's what we'll talk about when we talk about immigration in a few minutes. But so they should have been stuck, but were they practically, as a practical matter, stuck? No, because the Ninth Circuit bails them out and lets them provide an entirely different rationale in litigation, and in fact, not even in litigation, on appeal before the Ninth Circuit.
So before we get into that, my other this might turn into a question given your observation. So we know that in the tax court, they said, all right, you're losing on State Farm grounds, but by the way, if we were in a Chevron type of analysis, you would have lost under step 2 anyway. This would not have been a permissible regulation. So is that the hook that they needed to argue the CWI angle on appeal?
You mean, did the alternative decision for Chevron give them the room they needed to argue? I mean, maybe, but the tax court. I mean, there is one of the disputed elements both in the tax court and I think in APA writ large is the extent to which there is a distinction between Chevron Step 2, which looks at the reasonableness of the agency's interpretation of the statute, and State Farm, which looks at the reasonableness of the agency's decision-making process. And so they are close in form.
You can't have an unreasonable decision-making process and end up with a reasonable interpretation of the statute, or can you?
Well, yeah, maybe you can. I mean, that's I think there's a lot of different modes of thought on this, and it probably deserves its entire its own podcast. I think there are some people that
next time.
Yes, that's right. We'll talk about State Farm versus Chevron Step 2. But yeah, no, it's a great question, and I think a really hard one, and one that I hope that tax lawyers will get a chance to invest more energy in as we become part of the larger picture of administrative law.
Yes, I'm looking forward. I think there are some good fights coming with
absolutely
some of the regulations that have been promulgated recently. So we have a lot to look forward to. That's
right. So what happened at the Ninth Circuit, right, is the government essentially changed its argumentative angle here. Its argument was it walked away from what's in the preamble, and it largely walked away from what it argued in the tax court, and said, it doesn't matter whether or not this regulation complies with the arm's length standard. In fact, there is language in Section 482 that was added back in 1986, the commensurate with income language, or CWI, I think is the transfer pricing kids call it.
Yeah,
CWI said, well, no, that allows us to allocate income in a way that is commensurate with the income of whatever the intangible is. In this instance, in order to allocate income according to, commensurate with the income that it generates in the future, you need to consider stock option costs. Those are a genuine economic cost. But the Treasury takes it, as I think they had to, and the government had to take it a little further in their argument, and they essentially said, we don't care what the arm's length standard says. We're empowered to go the commensurate with income addition to the statute, which Treasury mentioned offhandedly in its preamble, essentially stands for the proposition that no, we don't need to look at the arm's length standard. We can justify this regulation based on the power that was vested in us by operation of Congress and the commensurate with income language. So it's a pivot.
It is a pivot, and it kind of ignores, or to give credence to that argument, ignores the tax court's articulation, because they did talk about commensurate with income, and they said, look, arm's length standard and commensurate with income are both in the statute. So, I would imagine that one should not take primacy over the other in terms of conceptual relevance. And in fact, the tax court said CWI is meant to supplement arm's length, not supplant it. And so when Treasury says, we don't have to worry about arm's length because CWI says that you have to recognize benefits of the cost sharing arrangement in a manner that gives you a benefit that is proportionate to the cost. That's what cost sharing says. CWI is just another articulation of that. And if you're not splitting costs in a manner in which unrelated parties would do so, I don't see how you could ever get a result that is commensurate with the income that the intangible generates, right?
Right.
And so you have to read those together for Treasury to be able to abandon its arm's length position altogether and switch entirely to whether or not these regulations are a way of effectuating a result that's commensurate with income, effectuating a cost sharing that results in income that's recognized in proportion to those costs you split. It gives this transfer pricing practitioner cognitive dissonance.
Yeah, right. I mean, and this is a problem at the core of Section 482, in a sense, right? I mean, there is this element of, there is a subjectivity objectivity issue, because you're sort of the principle, the objective principle is look to what others do, which is in a sense a subjective principle. So that's another treatise that we'll write in another podcast. But I think that you're right. I think there was a bit of this case, at least in the press and in the sort of the broader dialogue, did take on a kind of it went off on a tangent to a certain extent, which was this tangent of, well, does the arm's length standard always require you to look at real transactional evidence, or can you disregard that evidence? And that seems to me like it's close to the right question, but it's not exactly the right question, because the right question here is, even if you think that Section 482 always requires you to look at transactional evidence, and it might, I mean, I think one of the arguments that sort of cropped up over the years on this and in Xilinx is, well, look, yes, you taxpayer are substituting the for the arm's length standard, you are substituting one of several specified methods. You're saying you just have to use the cut or cup method. right? You just have to look at comparable transactions.
Mhm.
And that was a smart argumentative move on the government's part to sort of reduce the taxpayer's argument to this, oh, you're saying only one method is acceptable. I don't think that's quite what taxpayers meant. But the real question is, if there is transactional evidence as between parties at arm's length, third parties, which there was in
Right.
this instance, does the agency have to consider it? And I can't get to anything other than yes as an answer for that. Now, the Ninth Circuit didn't.
Right. I think they have to consider it, but they may at the end of the day decide that goes to method. It may not be the best method to look at.
That's right. That's
use a
right.
cup or a cut, and that's fine. But to your point, it has to be weighed.
The agency in its rulemaking process
Mhm.
needs to explain why it is that this evidence of what parties would do at arm's length does not determine the outcome in these instances. And
Right.
I think that if you were to say the arm's length standard is necessarily requires you to use a transactional method, then you would come out with the answer that yes, Treasury could not have enacted this regulation in the first instance. But at any event, Treasury at least had to make an effort to deal with this evidence, and it
Right.
didn't.
Right. It was a smart argument, but it was kind of a red herring because we're not asking Treasury to apply any of these methods to come to a result.
Exactly.
Right. And
exactly.
so it is a best method kind of argument, but we're not into methods at this point. We're just into determining.
Rulemaking.
Yes, we're determining whether or not Treasury weighed the evidence and properly rejected it, but you got to weigh it.
Right. So what happens real quick, what happens at the Ninth Circuit is that the Treasury wins on these arguments, and it was a little bit of a free for all. In the first instance, one of the judges who initially voted for Xilinx or against Xilinx in the Ninth Circuit decision, Judge Thomas, who's now the chief judge, was one of the judges on the panel for Altera. The government won in a 2-1 decision. One of the judges who sat on that panel passed away before the decision came out. The Ninth Circuit went to the extraordinary step of actually withdrawing that decision, adding someone else to the panel, and reissuing another decision in which Treasury again won in a 2-1 decision.
Mm-hmm.
So here we have a 2-1 panel decision overruling a 14-0 tax court decision, and the taxpayer moved for a hearing en banc, lost, but had a lot of dissenters, and it's I think 4 dissenters in its court. And when they and even in the panel decision, the 2-1 decision, there's a dissent there as well, which is powerful and fairly well articulated. One of the issues that sort of factored had a lot to do with the Ninth Circuit's decision was this, or at least the Ninth Circuit dissent, was the notion that this commensurate with income language is irrelevant here because we don't have a transfer of intangibles, and that's what implicates the commensurate with income language. But that's beside the point. So the taxpayer lost, Treasury won, the regulation stands, taxpayer petitions for cert gets denied. And not a shock, right, that cert gets denied. It's not like there's another circuit court out there that has one of these cases. And in fact, it's unfortunate because I think the taxpayers for whom this is the biggest dollar issue are, for the most part, Ninth Circuit taxpayers.
Circuit. So there will never be a circuit split.
Well, I mean, one can hope.
One can hope, but it's highly unlikely.
Yeah. So
where are we now?
Yeah, so let's talk about immigration for a minute.
Mm-hmm.
Because
here's our hook.
So yes, Altera loses and cert isn't granted, but the week before the Supreme Court denies cert, in this case, they actually decide to strike down the Department of Homeland Security's rescission of DACA, of the deferred. I'm going to forget all of the
Deferred
acronym.
action for childhood
Arrivals, right?
Yeah.
So, and in doing so, this was obviously a priority for this administration to gut. DACA was in the first instance an administrative. It was an agency action by the Department of Homeland Security. It was not legislation. I think everybody knows the basics of what DACA does. Allows folks who arrived here with their parents to remain here.
Arrived here without legal immigration status.
Without
as
legal
children
as
under
children.
18. And further, if you were in university. So studying, you could stay till 22 or whatever, however old you were.
So DHS decides to strike this down. Now, and this comes out of a series of decisions that culminated in a Fifth Circuit decision that actually held certain elements of DACA to be impermissible. Those elements had to do with providing benefits to folks who were here on this status. And the then Attorney General, Jeff Sessions, said we should strike this down and wrote a memo to the Department of Homeland Security. And Department of Homeland Security essentially said, we are, because of this Fifth Circuit decision and because the law is what it is, we are rescinding DACA. And obviously a flurry of lawsuits rightly followed, including a challenge from the NAACP that said that this is actually not a valid action under the APA. You have not provided us with a rationale for this agency action. This is too thin, and you didn't explain it very well in a nutshell. I don't want to go in too much into the immigration law here, but
that's not our wheelhouse.
Right. They actually, so the NAACP prevailed on this APA claim in the DC Circuit, and so the Department of Homeland Security went back and said, okay, well, we're going to actually provide you. It was sort of a reversed and remanded, but you go ahead, agency, and fix it and provide us with a cogent rationale for rescinding it. And
emphasis on cogent.
Cogent, yes. And Department of Homeland Security tried and offered some other alternative explanations. And so that case ends up in, so obviously that gets challenged, that agency action gets challenged and ends up before the Supreme Court in the case that was just decided, the University of California Board of Regents brought. So that case ends up before the Supreme Court. The case is about whether among other things, whether the Department of Homeland Security complied with the Administrative Procedures Act in rescinding DACA. And it looked at factors that were actually highly germane to the dispute in Altera. One of which was, what do we look at when we decide whether or not the agency complied with the APA? Do we look at the first sort of threadbare justification that we got from the agency, or do we let them have a second bite at the apple when they make this more comprehensive, if not fully explanatory attempt at justifying rescinding DACA? And the Supreme Court said, you're stuck with one.
Not surprisingly, right? Because in the law,
right.
We really don't like two bites at the apple, generally speaking.
That's right. And if you're an agency and we're governing what you're doing, you can't act first and explain later.
Right.
Right? That makes sense, and it's good policy by the Supreme Court. But one of the things that it calls into question about Altera, obviously, is that when Treasury enacted the cost sharing reg, it came out in the first instance said this is compliant with the arm's length standard, and this is consistent with the arm's length standard. And only in litigation did it come back and offer this commensurate with income rationale for the regulation. And if you look at the Supreme Court's decision, it's not just sort of baked into the actual decision that we can only consider the agency's initial action. It's also baked into what Justice Kavanaugh writes, where he basically says it's not, yes, Department of Homeland Security did this after the fact, but it wasn't as if that was just a position they chose in litigation. In our case, Altera, it was a position that they chose in litigation. The Ninth Circuit will tell you that that was somehow the position that they chose in litigation was implicated by the preamble in the first place. I think that deserves a much closer look.
It may be. I mean, there are a lot of words in the preamble, but the government didn't talk about them below.
That's right. That's right.
Right? So
That's right.
Just because the word appears does not mean that the Treasury argued it below.
It shouldn't be enough. That's right. And if we're really requiring agencies to provide a cohesive explanation for what they're doing, they ought, if they actually thought that the commensurate with income was something that allowed them to do this, they should have said so.
Right. It only would have strengthened their claim. One would think that, I don't know, you're the litigator here, but you tell me, don't you bring all of your best arguments to bear the first time?
You do. Although I will say a word in Treasury's defense there, if you're doing something that is you're worried about this arm's length question in Xilinx, offering an alternative explanation that is inconsistent with the arm's length standard might not be something you wanted to do. So
you would just say that you argue in the alternative. It's consistent with arm's length. Alternatively, one could look at commensurate with income.
That works great in legal briefs. I'm not sure how well agencies can use that sort of tactic. And then the second element of the DACA decision that's interesting and theoretically relevant to the Altera case is one of the things that DHS did not do in either of its explanations is provide any consideration to the kinds of reliance interests that are implicated by for citizens who came here involuntarily, who didn't have status, etc.
Right.
Those people have a lot at stake.
They do have a lot at stake.
So for people without legal immigration status, there's a lot at stake. And those reliance interests are enormous. And it is reasonable for the Supreme Court to say to DHS, among the considerations that you needed to address in rescinding this act are these reliance considerations.
Right.
They're front and center.
Changing people's lives. This is a big deal. And you can't just pull the rug out from someone without following these procedures.
That's right. And there is an argument that same kind of consideration should have operated in Altera. Now, obviously, we're not talking about deportations here, right. But the fact remains that Treasury was squarely confronted with this evidence of arm's length behavior among other taxpayers, and it does little more than sweep that evidence under the rug in its preamble. So if you are, if the Department of Homeland Security had to consider those reliance interests, it is not a far leap to say that Treasury should have at least said something more about the arm's length evidence that it was confronted with in enacting regulation.
Absolutely. So we've kind of come full circle here, because now we can be happy that tax exceptionalism doesn't really exist anymore. And so this DACA case is relevant in the tax space, right?
Absolutely.
Before it would have been like, oh, well, that has nothing to do with tax, and okay. But now, absolutely relevant. So.
Right. So hopefully we will be dealing with a bunch of Administrative Procedures Act fights in the future.
I think it will be. I really do. I think it'll be interesting to hopefully get to participate in. So we'll see.
That's right. That's right.
We'll see. So we've kept our listeners longer
too
than
long.
Usual 30 minutes or so. But this was a good chat, and I think it was worth the extra time.
I hope so.
So next time we will bring you a more concise, insightful analysis of some thorny tax issue.
This is probably actually, in my defense, this is probably one of the shorter song and dances that I've done on the APA. So
that's probably true. And listeners, you have been spared. I have not. I've heard the longer version. We'll see. So until next time, send us ideas. Send us ideas, right?
That's right. Our email is podcasts@milchev.com. We'd love to hear from you.
Yes. Until next time. Thank you.
Thanks.